This meeting is being recorded.
All right, for those of you who are watching this on record, good afternoon or morning, whatever time it is when you're watching this. As I told our live audience, my name is Maya Zivell. I'm a fair housing attorney at Prairie State Legal Services, and I'm here to talk to you about the new fair housing laws. I'm going to share my screen again. And just to recap what I just said, before we started the recording, these are the federal protected classes. These are the groups that are protected against housing discrimination anywhere you go in the country. Before I move to the Illinois law, just a couple of things about the discrimination under the federal law. I wanted to give you a couple of examples of what discrimination could look like. So examples are, and this kind of actually applies to discrimination at the state level too, but just kind of like to get you to start thinking about it. So misrepresenting that a property is not available. So lying to somebody, telling a landlord, telling a tenant that something is not available when it actually is available. Now, remember, when you are thinking of these things, to make it illegal discrimination, it has to be these actions have to be done because of someone being in a protected class. So a landlord just lying about the availability of housing because that landlord just didn't like my personality or something, that's not illegal discrimination, or they didn't like the color of my shirt. But if the landlord is lying to me about availability of the housing, saying it's not available because the landlord doesn't want to rent to me because I have children, because of my religion, my gender, things like that, that would be illegal. That would be a fair housing violation. Okay, steering somebody, so directing somebody in the rental or purchase of a house, or so that this could be, other than their preferred area at the rental level. And I think I'm just going to limit my presentation today to examples with rentals. I know fair housing laws also apply to sales as well, but I think most of my examples, I'll use landlords and tenants as examples, just because I think that's probably what the majority of people on this call are, either landlords or renters. But everything does apply to sales as well. So steering somebody. So maybe a landlord puts certain groups. Maybe there's a big apartment complex, and the landlord puts. Maybe there's a few buildings, and the landlord puts all the families with kids in one building. That would be steering. That would be segregating them in one part of the complex based on their familial status. Different terms and conditions, charging different amounts to different people based on, maybe they charge a higher amount to a family with kids, or they to somebody with a disability, or to somebody because of their race. So different terms to the lease. Maybe they will allow the person to rent there or to buy there, but having different terms based on someone being in one of those protected groups, that's a type of violation. And then
Illinois.
Or refusing to negotiate with someone too. Okay, I'm going to try to speed this up a little bit. The last thing I want to just mention about on the federal level is just like in 2 minutes, the rights that people with disabilities have for reasonable accommodations and modifications. And that's only because in my typical fair housing presentations, this takes up probably about half the training, and I always get so many questions about it. So I just wanted you to put it in the back of your head in case you want to, just so that you know about this right, if you did not already, that people with both mental and physical disabilities have the right to ask landlords for these reasonable accommodations for changes or exceptions to rules or policies if it's somehow related to their disability. So like asking for permission an emotional support animal in a building that doesn't allow pets, or asking to be transferred to a first floor unit. For somebody that can't climb the stairs, making a reserved parking space for somebody near the front of the building because it's harder for them to walk that extra distance. Those are all examples of reasonable accommodations. And then people with disabilities also have the right to reasonable modifications, the right to make physical changes to the property. Like there's some pictures here, like making a bathroom accessible, widening a doorway to get a wheelchair through, adding a ramp, a smoke detector that lights up for someone that's hearing impaired. Those are examples of modifications that people with disabilities have the right to request those as well. Okay, moving on. Illinois Human Rights Act. Remember, I mentioned we have that federal law, the federal fair housing laws. In Illinois, we also have the Illinois Human Rights Act. So we also have protections against discrimination in housing under this law. So we have in Illinois also, we have protections based on discrimination based on age. So landlords can't discriminate in Illinois. That protects people age 40 and older. Landlords can't discriminate against people based on if they are 40 years old or older. It doesn't protect people younger than 40. Marital status, so treating people differently that are married versus single, their military status, and that includes unfavorable discharge from the military, order of protection status, and that does protect only the person that has the order of protection. So the victim who has an order of protection against somebody else, pregnancy, sexual orientation, which includes gender identity, arrest record, and our new one and our hot topic for today, source of income. Right now, I promise you that in about 2 minutes, we will move on to source of income, which is what we'll talk about. We'll talk about source of income for the rest of the time. But I just want to mention one thing about the protected class that came, the most recent one before source of income, which was arrest record, because a lot of people don't know a lot about that one too. So arrest record became a protected class in Illinois as of January 2020. So the law in Illinois now says that landlords cannot consider arrest records. So like when someone's applying to rent a place, if they have an arrest record, a landlord is not allowed to use that arrest record in deciding whether to rent to them. But I says arrest not leading to conviction. So it's a pretty narrow protection. It only protects people who have arrests that didn't lead to convictions or juvenile records or records that have been expunged, sealed, or impounded. So if you conviction on a record, a landlord would be allowed to consider that. But if it's an arrest that didn't actually lead to a conviction, that's a protection now, fair housing protection in Illinois. And that was the most recent protection we had in Illinois until source of income. So here, I told you in 2 minutes. So I hope I made my time deadline for myself. Source of income. So it was passed into law. It was signed into law by the governor in the spring of 2022. I think it was passed by the legislature in April. It was signed in May, but we're only talking about it now because it only became effective January 1st of 2023. So we've had a few months to think about it and kind of prepare and to what's coming, but it only just took effect. Just over a week ago now, right? So what is this new protection? So under the Illinois law. So I actually put in bold for you the definition. That definition of how of source of income is exactly like word for word how it's written in the actual law. So under the Illinois Human Rights Act, as of January 1st, 2023, it is illegal discrimination in a rental or sale in a real estate transaction to discriminate based on someone's source of income. And source of income is described as, or defined as the lawful manner by which an individual supports himself or herself and her dependents. Now, that is a very general definition. You'll notice that it doesn't, the definition in the law doesn't give examples of what source of income is.
Exactly.
Right. So there's some states and places or jurisdictions that have source of income protection. A lot of them are worded a little differently, and some other places they actually give examples. Like in Naperville has had a source of income protection for a while. They actually give examples what that means. There's no examples in the state law, but here are some examples of what I think source of income could include. Basically, what it means is that source of income think of it basically as where you're getting your money from to pay your rent. So it would be discrimination for a landlord to treat someone differently because of where they're getting, how they're paying their rent. So landlords that require that somebody be employed to rent there, that they have a job, and that's where they're getting their money from to pay their rent. That is now a source. That would be discrimination under this new law. Here are other examples of other ways that people might, besides employment income, other ways that people might pay for their rent, right? So these are other sources of income: housing choice vouchers, veterans benefits, Social Security, or all these other ones. Health care benefits, SSDI, these are all child support. So these are all examples of other ways that someone might pay for their rent. That emergency, if you'll notice on the left side, on the left column, that bottom bullet point, emergency rental assistance has a question mark. That's intentionally a question mark. The reason is because, so some of you may know, this started a lot during COVID. There have been a lot of new programs that have been developed in COVID, rent assistance programs, and there's all different ones to help tenants pay rent, either if they fall behind rent, or if there was a COVID related reason that they couldn't pay their rent, or maybe they're in eviction court. So some landlords will not accept rent assistance. They just won't, or maybe they'll only accept it in certain circumstances. So the question is whether emergency rent assistance is considered a type of source of income. In other words, if a landlord says they're not going to accept rental assistance, is that now discrimination under the new law? That is not a question I have the answer to yet. And the reason I don't have the answer to it yet is because it's such a brand new law. It's only been in effect for 12 days that nobody has tried to litigate it yet. So nobody's sued anybody over this new law yet. And that's how a lot of how we decide how interpretation of the law how we get interpretations of the law is when someone sues somebody else, and then we see how the court ruled on it. So we haven't had anybody yet file a fair housing complaint because their landlord rejected emergency rental assistance under this new law. So whether something here is or isn't protected, I cannot say with 100% certainty, because it's going to depend on how courts rule on it in the future, or how the Illinois Human Rights Commission, which also enforces fair housing laws, how they view it, and or they might offer guidance on it. So sometimes sometimes there'll be like guidance that'll be issued to interpret laws. So like in Naperville, remember I mentioned in Naperville has had a source of income protection for a while. in their, I believe that in their definition, it actually gives rent assistance as like an example. It also says housing choice vouchers. So it's pretty clear that rent assistance is protected under that ordinance. But like I said, we don't know. We don't know about any of these. I mean, I have my predictions, which I'll show you, but that's kind of the theme, is that a lot of the stuff, it's going to take some time. It's going to take some time to see, you know, how the courts go. It's important to know fair housing laws in general are discrimination in housing. Not only protects people in purchase transactions, so people that are buying homes or selling homes or renting, it also applies to other types of housing providers like banks who give out mortgages, insurance companies that give home insurance. There's other types of housing providers that have to follow fair housing laws. But this new law, this new source of income law, explicitly, it only protects rental and purchase transactions. So it does allow banks are still allowed to take, who are in other contexts not allowed to discriminate. They are still allowed to take source of income into consideration if it's in compliance with other law, meaning they can still look at your income when deciding like whether to give you a loan to buy a house or something like that. I do see the questions about the program, the Section 8 program. I think I'm going to address it. So maybe we'll go back to it at the end if you feel like, you know, you have a follow-up question on it. But okay. So here are some examples of what housing discrimination could look like in the source of income context. So first of all, here at Prairie State, well, here's some issues that we see currently, that we see a lot. We get a lot of clients who have housing choice vouchers who aren't able to use their vouchers because like they can't find a landlord that will accept their client, their voucher. And oftentimes those clients are homeless. We also see clients who, you know, they can find landlords that will accept their vouchers, but only in certain pockets of the county. So, you know, that are what, you know, call like not high opportunity areas. Maybe they're further from grocery stores, transportation. So only certain communities in the county are more likely to accept the vouchers. And then also, and this is also a heartbreaking situation when we see a client that actually, you know, been on the wait list for years, finally gets a voucher, and then it ends up expiring and they lose the voucher because they can't find anywhere to use it. So those are big things that we see at Prairie State a lot. So under this new law, I kind of broke it out into 3 categories of what discrimination could look like, source of income discrimination. So the first category I call overt or intentional acts. So these are examples of like discrimination that is intentional. So the landlord intended to discriminate. And these are usually pretty easy to spot. If something like this happened to you, you would probably be able to identify right away that you were discriminated against. For example, an advertisement that says, we don't accept Section 8, or a phone call from someone saying we don't accept Section 8, or you know, we only accept people that have jobs to be able to rent here. We don't accept rent assistance, things like that. Those are if I was a renter and a landlord said any of those to me, I would because I know what this new law is now, I would be able to tell right away, okay, they're discriminating against me based on my source of income because they told me. Obvious discrimination. They told me straight up that that this is, you know, that they won't accept my voucher. The second type of discrimination is, you know, that the second category, I guess, that I put is covert or difference in treatment. So this is still, these are still examples that I'm about to give of intentional discrimination. So these are, this is discrimination where the landlord still intended to treat the person differently, still intended to discriminate, but it can be a little more subtle or a little bit harder to prove. It usually requires a witnesses or some kind of other investigation or evidence to be able to prove that it happened. So, for example, different treatment, treating people differently based on their source of income, saying, you know, only running background checks of certain people. It's okay for landlords to run background checks. There's nothing illegal about running background checks, but only running background checks on certain people, but not other people, maybe a policy that, well, only running background checks on people with vouchers, for example, but not people that have jobs. That's a difference in treatment. You know, saying that, you know, proving that they have a certain income, or only, you know, only having certain rules that only apply to people based on, you know, different sources of income, like only running credit scores for certain people, things like that. So these are examples. Again, landlords in these examples intended to treat the people differently, but as you can see, if, you know, if this thing happened to you, it might be harder for you to even know that you were treated differently unless you had other evidence. If I had a voucher and, you know, my landlord ran my background check, it would be hard, unless I knew of someone that was applying there that didn't have a voucher, that didn't have their background run, I would never know that I was being treated differently. That's why I'm saying it's a little harder to prove. Sometimes it requires like a witness, someone to tell you something else, or some kind of an investigation. And then the last type, the last category, this is one I think is probably going to generate the most discussion, is this discrimination where the landlord maybe didn't intend to discriminate, but created a policy that effectively discriminates. It's in fair housing world, we use this term called disparate impact, which basically it's a neutral policy that has a discriminatory effect. So what do I mean by this? What do I mean by this disparate impact of different a neutral policy that that may actually end up treating people differently based on their source of income? So here I gave this example because based on my conversations so far on source of income with groups and people, this is just the policy that I think that seems to be coming up a lot so far in our discussions. You know, some landlords have policies. You have to make a certain number of times the rent to live here. You have to make, so maybe there's a landlord that has a rule. You have to make 3 times the monthly rent. So if the rent is, you know, $1,500 a month, that would mean you would have to make 43 times that would be, you'd have to make $4,500 a month to be eligible. Okay, that's a neutral policy, right? So that landlord is not saying, I'm not going to rent to anyone with a subsidy, with a voucher. But I mean, but think about it. This program effectively does prohibit, or makes it basically impossible for people that with vouchers to ever be eligible, because somebody that has an income of $4,500 a month probably wouldn't have a voucher to begin with. So like I said, it's a neutral policy, but it has a potential discriminatory effect. So what's an example? So let's think of what an example of like a policy, maybe how a landlord could get around this, still have a policy where they want to prove, you know, 3 times the rent, but still keep it within the parameters of the law, but treat people, you know, fairly, and not have source of income discrimination. So what about what about a policy where the rule is the applicants don't have to prove that they make 3 times the rent, but you just have to prove that you make 3 times your portion of the rent. So if I have a voucher, and at the place where I'm renting, you know, the housing authority pays, say, $900 a month, and my portion is $100 a month. Having a policy that I have to show that I make at least 3 times my portion, so at least 3 times $100, $300 total. That's more reasonable. That would not have a discriminatory effect on people based on their source of income. The Cook County has had sometimes there's some counties have and cities have more fair housing protections. Cook County has its own fair housing laws as well, and they've actually had for many years source of income as a protection in Cook County. So this law, or a very similar law, has already been in effect in Cook County. And there's also one in the city of Chicago specifically. They also have source of income. So a lot of what I'm going to say, like I said, we don't have any cases where judges have actually ruled yet on source of income at the state level, because the law is only a few days old, but we can look for guidance to other states, other cities that already have source of income, and see how they've dealt with these issues. So the Cook County Department of Human Rights that enforces the fair housing laws at the Cook County level, they actually have come out with guidance little less than a year ago in 2022. They explicitly came out with a memo saying exactly what I just said basically exactly what I said on the last 2 slides, that a 3 times the rent policy is that it could have a potential of discriminating against people based on their source of income. So this is a better policy showing, 3 times your portion of the income. And I also wanted to, like I said, and this, I'm sorry I'm going to repeat myself, but this is kind of like the part of the theme is that the law is not decided on a lot of what we're talking about. I mean, I can tell you what the law is. I can tell you how we interpret it, how we predict things will happen based on what's happened in other places. But the law is not decided on a lot of the things, right, at the state level. But in other jurisdictions, these are some cases in other places, like I said, Cook County, and then in other states where tenants have challenged those 3 times the rent policies, and where courts have found, 3 times the rent is discriminatory based on source of income because it effectively, rules certain people out. That bottom case, I'm only referring to, it's a pretty recent case, that because it's just, from less than a year ago, is this case from New York. It was this apartment complex in the Bronx, Parkchester, and they actually have over 6,000 units at this property. And they had a policy that in order to be eligible to rent there, you had to make at least $62,000 a year. So the plaintiff in this case, she single mom with 2 kids with a voucher. At $62,000, she tried to apply and was denied because she didn't make $62,000 a year. But if she had made $62,000 a year, she never would have been eligible for her voucher. But she still had the money to pay for the rent. Her voucher covered the whole rent. So, filed a fair housing complaint, and the court ruled in her favor and actually explicitly said, this is exactly why we don't have these policies, because it has this discriminatory effect on people with other sources of income. So, little takeaway here I guess this is more for landlords, maybe housing providers, they may be concerned. Is it now mandatory? And I think I saw that I think someone talked about that. I think someone mentioned that in the chat too. Okay, does a landlord have to now accept a voucher? The answer is no. No, but no. If someone comes to me, landlord, me, Maya, and with a voucher, I don't automatically have to say, okay, you have a voucher, I have to admit you. But I do have to follow, I have to give them a chance. I have to give them a chance to go through everything that tenants that don't have vouchers, that are applicants that don't have vouchers go through. I have to have policies that consider them based, policies that that consider them in the same way as you consider people that don't have vouchers. So, for example, if landlords are still allowed to have policies that they run background checks, right? So as long as they run background checks on everyone, and if someone with a voucher has a background check that does not pass the the threshold that the housing provider has, their policy, then in that case they can possibly deny the person, or maybe they run credit checks. A lot of landlords run credit checks when you're applying, and that's perfectly legal as well. As long as, like I said, as long as you're treating everybody the same, meaning as long as your policy is the same for everybody, regardless of your source of income. So if a landlord has a policy, we don't accept anybody with a credit score under X 500 or something like that. As long as they're applying that policy, they're running everybody's credit and they have that policy for everyone. Then in that case, someone with a voucher didn't have the high enough credit score, they could reject it. Or maybe, landlords look at eviction records, right? So somebody with an eviction, landlords are still allowed to take past evictions into consideration, or references from call someone's old landlords and get references and see if they get positive or negative references. All these things that landlords were doing, you can still do. You can still have those rules. As long as, like I said, as long as the policy is being applied equally, as long as you're doing these, you're running credit, you're doing background check, you're reviewing, eviction history, references, all those types of things. As long as you're doing it for everybody and you have the same threshold, the same rule, then yeah. But it is mandatory to at least consider the person, right? And to not reject somebody just on the explicit basis that they have a different source of income, that they have a different way to pay their rent other than a job. That decision just by itself, that's what source of income discrimination, really is. All right. Oh, good. We still have some time. I think I do see some questions. I think I'm going to keep going through this and then I'll go through your questions. One moment, please, just so I can get a little drink here. All right. Here are some concerns that many landlords have about participating in the voucher program. And like I said, there have not been any challenges, any cases, opinions in the court cases that have made decisions at the state level about this new law yet. But there have been challenges in other places. There have been challenges in Cook County. There have been challenges in other parts of the country that already have source of income laws. There have been examples where, where landlords have challenged it or they're defended against. These are some defenses why they're not accepting housing choice vouchers. I'm going to give you these examples, and then I'm going to tell you kind of what, in many cases, what courts have said about it in other places. How courts have responded to these potential defenses. So here's a few. I pulled some of the ones that I thought that I've heard a lot, that I thought were probably some of the more common ones, more common concerns. So maybe concerns that the unit won't pass inspection because participation in the housing choice voucher program means that the housing authority, before before it approves the lease, the housing authority has to come and do an inspection, right? So maybe a landlord that is worried, why should I participate in the voucher program? Because my unit's not going to pass the inspection anyways, or maybe the inspection process takes too long. I don't like working with I just don't want to work with the voucher program. All these other things here, other things like that. So let me give you some examples. Unsuccessful defenses. So first of all, there have been some challenges in other places where housing providers have argued where it's not explicitly defined in the law. And like in Illinois, like I said, it's not explicit. There's no examples of what source of income is, but which just says the lawful manner by which you pay your rent. But so there have been some challenges in other places. Are vouchers even considered a source of income? So is refusing to rent to someone with a housing choice voucher, is that discrimination? I can tell you that this was challenged in Cook County, and this is a case that came out of the Cook County, out of the Illinois appellate courts in challenge to the Cook County ordinance, which found that yes, the Cook County ordinance, which is basically the exact same definition as the Illinois law, the court interpreted source of income to include Section 8 vouchers. Okay, another one. So under the voucher program, the housing authority requires that there be like an addendum to the lease. There's certain extra parts to the lease at the end that HUD requires that the housing authority puts on the end of leases that they are where they're allowing people to use their vouchers. And so some landlords may not like that. There's additional rules under those. There's additional provisions to the contract that if a landlord accepts someone with a voucher, they have to agree to as well. That's been challenged too. This was a challenge, like again, not at the Illinois state level, but it was challenged in Chicago, the Chicago Human Rights Ordinance, the Chicago Fair Housing Law. It was challenged in 2000, and in that case, the Chicago Human Rights Commission, which is, Commission on Human Relations, who enforces the fair housing laws in the city of Chicago, found that that's not a good, that just be objecting to the program because you don't like that extra lease, that extra addendum to the lease, that does not cut it. That's not a good enough defense to reject participating in the program. Here's another one kind of similar. Actually, is this the same case? No. Okay. This is another Chicago case, another case at the Chicago level where it was challenged, where a landlord did not accept a voucher because they just didn't want to. They did not want to accept. They just didn't like to work with the voucher program. They didn't like the fact that, they wanted to increase the rent and the housing authority wouldn't approve it, or the inspection process. Yeah, sometimes depending on the county or where the housing authority is, if it's a busier housing authority, sometimes you have to wait maybe even a couple weeks until they can get an inspector out there. So some landlords might not like that delay in the inspection process or failing the inspection. Belief that that a landlord believing that they might get more complaints from Section 8 tenants. Those are all things that were talked about in this case, at this Chicago case, where the landlord said these were reasons that they did not want to work with the housing choice voucher program. And in that case, sorry to skip ahead there for a sec, the court found that those were not, those were general objections. Those did not rise to the level of, those did not protect the landlords against discrimination. Those were not valid defenses. They did not accept, the court in that case did not accept those defenses to refusing to participate in the voucher program, and found that it was still discrimination. However, it's not all, like I said, case law it's a little mixed, and this is another Chicago case where I just want to see what, yeah, oh, they're both, I thought they were both from the same year, a little later, but same year, from 2000. This is another case at the Chicago level where the court did acknowledge that there are some cases where a landlord may be prohibited in accepting vouchers. In this specific case, the court found, this is a quote directly from the decision of the court, directly from the decision in this case. If the landlord could show what they called credible evidence, specific evidence, not just generally they don't like the program, they think it's going to take a long time, they don't want to wait for payments, things like that. But if there was a specific credible evidence making where they would be burdened by it. So like in this case, the landlord, there was the delay in paying the landlord, the housing authority's delay in paying the landlord then caused the landlord to be delayed in paying the landlord's mortgage. And then the landlord got penalties on their side from the bank for not paying their mortgage on time. And that was as a result of getting late payments from the housing authority. So in that case, the court found that, yeah, if you can show a specific burden with, that was an example they gave, specific burden with credible evidence. In that kind of a situation, a landlord might be permitted to not accept the vouchers. But that's the only case I have. That's the only example I have with that information, because those cases are few and far between. The vast majority of cases challenging that voucher program have found that landlords do have to accept vouchers, or else it's source of income discrimination. But as I reminded you before, and I remind you again, I'm sure I can't say with 100% certainty what's going to happen at the state level. I can tell you with 100% certainty that I'm sure someone's going to challenge. It's going to be challenged. I'm sure that there'll be, someone that challenges the law, or maybe a tenant that files a fair housing complaint against the landlord for refusing it. And this issue I'm sure we will get guidance from the courts, because the law will be challenged, and the definition, will be challenged, but we just don't have it yet. So possibly if I do this presentation like a year from now, maybe I'll be able to tell you a little bit more, give you more examples, but I'm sure we'll get there. We'll get more guidance, probably, possibly this year or next year. Last thing I wanted to say, and then I'm going to go back and I'm going to address any questions in the chat. And then if anyone has any other questions after that, I can definitely address those as well. I'm glad we have a lot of time to address questions. I wanted to tell you what are if someone believes that they have been discriminated against, what are their remedies? How can they, what can they do? And well, certainly come if you're in Lake County, and you can come to Prairie State if you are a tenant that you believe is, you believe you've been discriminated against, and we may be able to help you. And, my perspective is always, if we can resolve it without filing a complaint, without suing, like just through negotiation is always the most effective, is hopefully that's always a good place to start. So I probably wouldn't always rush just to file a complaint, right? We want to try and negotiate, maybe sometimes educate. I think a lot of housing providers might not know about this new law yet, so it might take some educating like what we're doing here today, but informing them of this new source of income protection. But if it doesn't work, if someone still believes that they've been discriminated against, they do have the right to file a fair housing complaint if it's a federal fair housing complaint, you can file a fair housing complaint with HUD, but specifically if you believe you've been a victim based on source of income, because it's a state law, you have the right to file not with HUD, with the Illinois Department of Human Rights. That's, like I said, that's the Illinois agency that will investigate your fair housing claim. It's free, doesn't cost anything to file a fair housing complaint with IDHR, but it does need to be done within 1 year. They have a 1-year statute of limitations, so they will not accept any complaint if it's been more than a year since the discrimination happened. It can only be up to a year. Otherwise they won't review the complaint. It is free. The investigation, it's nice to have an attorney. You don't have to have an attorney at the investigation phase. It's mostly just, it's not like stepping in front of a judge. That's not the first step. The first step is investigation, where there's an IDHR, an investigator that'll ask, the victim, the person who filed the complaint, questions, will interview the other side to get their side, maybe gather documents, interview witnesses, things like that. So you can have an attorney. It's not mandatory. And then the other thing, besides having the right to file with IDHR, is that people who believe they've been victims of fair housing violations also have the right to file complaints in court. So if it was a source of income violation that you believe you were discriminated against based on your source of income, you have the right to file in state court, not federal court, because it's a state law. State court, federal court, if it was a federal law, you'd have that right. But both of them have the same statute of limitations, though, 2 years. So if at the court level you have a little bit longer, you have 2 years. They'll accept a case that you can file. You can have a case as long as you file it within 2 years of when the discrimination happened. There's pros and cons of both. I won't get into too many of the details. Filing in court usually involves costs, serving people and filing the complaint and things like that, unless sometimes you can get a waiver from the court depending on your income and if you apply for one. But going through IDHR, the Illinois Department of Human Rights, is free. I think that's the end. Okay, I'm going to put this up here for a few minutes just so that you can, while I answer questions, just so that if you want to take down the contact information, you can. That's my name, and that's my direct email address where you can email me. And then that's our toll-free number that takes you directly to our fair housing line. I guess I could have also put on there, you know what, I'm gonna actually put it in the chat. We have a general, let me see here. I'm gonna put this, we have a general phone number for Prairie State for our Waukegan office as well. I'm gonna put it in the chat here really quick. Like maybe if you had a question and it has nothing to do with anything we talked about today, a legal issue, you don't want to call the fair housing line, that's our general number, and that kind of takes you through a menu of different legal issues, and then you press buttons based on what you're calling about. But you can also just call this number. It goes to a voicemail that that goes to me and to another fair housing attorney, and we do check those messages. We try to get to daily. We have someone respond, follow up, and if we don't have enough information, we'll have that person whoever the person who calls back the caller, get more information, and then we'll kind of just make a determination whether it's fair housing, if we should interview them, or if there's another attorney that can help them, things like that. So you can always call that number, and like I said, I still will hear. You'll still get to me. You'll still get to me. I'll hear your message. It goes straight to me. So that's my contact information, and I think I'm going to scroll up now to give preference to, and then after I go through these, then I'll see if there's any other questions. But I'd want to give a little bit of preference first to people that anyone put any questions in the chat during the presentation. So I think I'm going to start with, let's see here. Yes, but I will answer that question first, Patrick, because that's probably a question a lot of people are wondering, and maybe if you don't want to stay and hear the questions. Yes, we can, Sarah, and that's why I hope it's good if you registered, LCHA has I'm assuming your contact information, so I could send you a copy of the slides.
Yes,
for you to, okay, great. So I can send Sarah at LCHA a copy of the slideshow, and then she can then share it with anyone who's registered here. So yes.
Yeah, that'll be great.
Okay, sure, that's no problem. So and then you'll have my contact information too. And I do mean that genuinely. Like, if you have any questions, even just general questions, please feel free to contact me. If you're not a tenant, if you're a landlord or a manager or something too, I do a lot of trainings for landlords and for management companies as well. There's some management companies in Lake County and in the surrounding areas that we do regularly train their staff, and we do for the LCHA staff too. So if you want a more in-depth, discussion about the law in general, that's, I'm happy to do that as well. Please feel free to contact me. All right, going back to the questions now. So I think I'm going to start with this one from Karen. Let's see here. So for a landlord who could be lying about a place being available, do you have to see the unit or house empty to prove that the act is not true? No, not necessarily. It's very case by case specific. So it just depends. It depends on the facts. It depends on the facts of the case. So I mean, in some cases, it might actually not be empty for a very long period of time. So maybe a landlord's trying to rent to, suppose the landlord's trying to rent to someone, and I'm going to use like disability as an example. Landlord doesn't want to rent to someone with a disability, and someone with a disability comes to the landlord, and says to me, no, I'm interested in renting here. And then I actually do have something available, but I say, oh, sorry, we don't have anything available. And then the next day, my friend who's not disabled comes and applies and asks if the same unit is available. And then, the landlord says, yes, I have something available. And then they sign the lease. So it doesn't have to necessarily mean that the house stays empty. Sometimes the proof is like, look, you told me that it wasn't available, but I know for a fact that, my friend here called you a day later and you said it was available. And my friend was not disabled. My friend was of a different race or something. Sometimes clients, it's hard to prove that, right? It's hard to prove unless you knew. That's something it's kind of hard to prove. Sometimes we have at Prairie State, part of our fair housing program at Prairie State, we have this program, it's called our testing program. And our testing program is, I'm actually going to stop sharing my screen so you can see me a little bit bigger here. I think that's, okay. I think that's good. Yes. Okay. We have a program here, a testing program. It's funded by HUD, and we can actually where we send out. We can investigate these cases. We send out volunteers, testers that we train. They're kind of like secret shoppers, where they pose as renters and they go. And so if a client comes to us and says like, you know, I think that they lied to me. I think that they were lying to me. I think that they just didn't want to rent to me because of my race or something like that. We could then take two of our testers, our testers, one that's white, one that's African American. We could send them out to go pose as renters and go, you know, pretty close in time and ask the landlord if something is available. Well, if the landlord says sure to our white tester and again says no to the African American tester, there we go. There we have evidence that we can use to support the client's claim. Okay, so hopefully that answered your question. But that's another really interesting aspect of our work too, is our testing program. Okay, so I don't think these next ones are really questions, just kind of like a little bit of back and forth, you know, whether the rent assistance is income or not. So like I said, it's to be, I have some opinions, but it's to be, I think it's to be determined. Let me see here. What else do I have here? Right. Okay. And I think I answered this next question about, you know, a question about what if a landlord doesn't want to work with the program? It's not that they don't like the people, they just don't want to work with the voucher program. And I think I gave some examples there based on, you know, how this has played out in other courts, in other places that have source of income laws. That's probably not going to be a valid defense. If someone challenges that as discrimination, it's very likely, I would say, there's a possibility based on how other courts have ruled that that the court will say that's not a good enough reason. Okay, so I think I'm going to scroll down here because there's just subject. Okay, so someone who doesn't accept. I see somebody that wrote there again that they won't accept the FARA funding. So I would say, because that's a specific legal issue, so I would actually tell that person to contact me, because then I can, you know, possibly open a case and we can give specific legal advice on that issue, on the FARA funding. But like I mentioned, you know, it's not settled. I can't say for sure one way or the other, but I can give specific advice on that to that person if you want to contact me. Oh, that's a good question. Yeah, about discrimination against, that age discrimination. There's a question there. What if it's a 62-year-old, right? If it's a community for seniors. Thank you for pointing that out. Yeah, there is an exception that's going back to like, not source of income, when I was talking about the Illinois protections and that we can't discriminate based on age. In Illinois, it protects people 40 and older. Well, there's an exception. There's a carve out in the law for communities, you know, these senior communities. So that would not be, yeah, there is senior housing and that would not be discrimination. If it's specifically like senior housing and it, goes through proper HUD protocols. But yes, that would senior buildings, and there's senior buildings all over Lake County, and they're not discriminating. They're not illegally discriminating. I don't know about the question about conviction. Is it based on crime? Oh, is it based on the type of crime? I think what you're asking is, like, is there any mention in the law about like any distinction between what kind of crime it is well, the short answer is no. The longer answer is, so remember there's nothing in Illinois that says, that prohibits landlords from taking convictions into account. Remember, just arrest records, but convictions can be taken into account. However, there's guidance from HUD. It's not binding, but it is. We have some pretty good guidance from HUD from a few years ago that set on like policies on best practices for landlords that look at criminal histories, and that landlords should look at kind of should take different factors into consideration. Not all landlords do this. This is what HUD is suggesting. Take different things into consideration when you're looking at someone's criminal history. One of them being the type of crime. Is it a violent offense that may be a safety issue for the rest of the community or not? How long ago was the crime? Is it something that just happened recently, or is it someone who has a conviction from a very long time ago? Things like that. So what type of offense, the length of time that has passed, things like that. Looking at things on a case by case basis. Is the person disabled? Was it something related to their disability, the crime? And maybe that person is now, has that, is not a danger, things like that. So looking at it on a case by case basis. Let's see what else here. So yes, so I think I answered these questions that, credit score, landlords can take credit score into account. Yes, as long as, like I said, equal policies, as long as the landlord is running the credit for everybody and has the same rules. So they can't say like, okay, if you have a voucher, you have to have at least a 700 credit score, but if you have a job, you only have to have a 500. It has to be the same rule for everybody. And let's see here, what else? What other questions do I have here? I'm going to let's see here. So I think, one second. I'm just going to mute. Sorry. I just want to make sure everybody's muted. Well, I can't figure it out. I think there's a little bit of feedback from somebody, but I don't know who it is. So if you could just, here, I think I found it. It's okay. If you could just mute yourself, but I think I'll just do it right here just so that we can, oh, never mind. Okay, all good. All right, next question. Let's see, what else do we have here? So yes, so like I said, everyone's gonna get a copy of the slideshow as long as you sign up. Okay, what else do we have here? Yeah, I know I see a lot of discussion here about the fairness, the landlords, and I know I recognize the concerns. I know that those are there are a lot of concerns by landlords. I can just tell you what the law is and how I predict it'll be interpreted, but I do know that there are concerns, and that kind of like I said before, I think that these concerns will come to light in cases, either cases where challenges to the law, or when a landlord is sued for not accepting a voucher and maybe offers these as defenses. Like I said, it's just going to take a little bit of time to see how courts come down on that. But what I'm saying is, our interpretation is that for the most part, that it would be a source of income. It would be a source of income violation to refuse to accept a voucher as the law is defined right now. Let's see here. What is the argument? Okay, I see. I want to make sure I get to if anyone else has any questions. But okay, so there's a question here about the argument to the landlord if for 3 times the rent if someone has SSDI and a voucher as 2 sources of income, but they don't have a third multiplier, rather a third source of income. That is a very complicated question. Good question, a complicated question. But I think basically what I was trying to say with the 3 times the rent thing is that a policy that says that you have to earn through your job 3 times the rent, where you can only, it has to actually be, you know, cash on hand that is yours, 3 times the rent. That kind of policy has a discriminatory effect on people who have other places where they get their money to pay their rent. So I don't think it's necessarily like one or the other, the SSDI or a voucher. It just, I think a best practice is just showing a combination of the two. If someone has enough, you know, based on all of wherever they're getting all of their subsidies or finances, they can show that they have enough to cover 3 times the rent. Hopefully that answered the question. Let me see here. Okay, so I see a question about, okay, applicant, okay, is this okay? Applicant provide written verification of all income sources, demonstrating net income equal to 3 times the monthly rental payment for which they are responsible. I don't want to say specific, like I'd have to see it like in context, but theoretically, it kind of, in theory, like I said, having something that says something about, yeah, that you have to proving that under the guidance that we have from, you know, Cook County and other courts, a policy that says to prove that you own, prove that you have, sorry, not that you own, prove that you have 3 times your portion of the rent, that is okay. I would point you also to, maybe I'll put a link to it in the slideshow, to the guidance from Cook County. Like I said, not binding, but, or actually I think you can look up also the cases that I cited on there too, where courts have kind of discussed it, or contact me like outside of this presentation too, if you want to talk more specifically. And so, yeah, I think that next question is like, how do we get to the rental application and put our income if we can't even get past the application? I think that means, I don't know, I'm not sure exactly what that means. How do we get past when we put our income? I don't know, does anyone want to explain that one to me? I'm sorry. How do we get through the application and put our income? I don't know. I don't know if someone can explain that one to me, from Lisa. If someone could just like, if Lisa or someone can like clarify in the chat, I'll come back to it. There's another question. How soon do landlords need to adapt to the new law? I've spoken with big landlords who say they're not set up to accept the voucher. The law became effective January 1st. The law was signed May of 2022. So there's been some, I think that was part of the reason, I'm assuming, I don't know. I don't have, you know, I'm not in the minds of the people that wrote the law, but I am assuming that's probably one of the reasons that there was like you know, more than 6 months wait. But as of January 1st, it is in effect. It is in effect now. So if a landlord on January 2nd said, I will not accept your voucher, I think that person has a potential fair housing claim, has a potential case based on source of income discrimination. No, it's effective now. That's why we're doing this presentation now. And I think I answered that. The next question, how far can you look back? Look back period. There's no set law on how far back. There's no set law. Different landlords have different policies, how far they look back. There's been some guidance from HUD on that look back period and, you know, what's reasonable, what's not reasonable. There's been some guidance, you know, that I guess the longer ago it was, the less weight it should be given, but there's no like set number anywhere in the law anywhere. Can a tenant sue a management company if they've been told to move or evicted at no fault of the tenant. I don't think I have enough information on that to answer that question. I think I would need to know. That sounds like that could be a yes, and it could be a no, depending on the fact. So I would say to that person, if that's referring to a specific issue, to contact our office directly on that, so I can talk to you about that. All right, so let me see. Oh, I have one more here. So, oh, good, and it's only $225. As a landlord, I normally have asked for 2 recent pay stubs to show that a tenant does make the rent reported. If I do this, is it now believed to be discriminatory? The answer is yes. The answer is yes, because that's kind of the same. Well, let me say this in general. I don't want to say I guess it depends on what the whole policy is. You can contact me all this. But I think just requiring that someone show proof from pay stubs that they make the rent, that's like the same as saying you have to be employed to rent here. You have to earn enough money to rent here, which if you make that connection, that's kind of like the essence of what the source of income protection. Yeah, you do have the right to verify. There is the right to verify income, but there's the right to verify income. But under the new law, if you can't require that, a landlord can't require that the income be employment income. The landlords have to treat wherever the money is coming from the same money. The sub is the same. Money is money. You can't require that it come only from having a job. That's what it's saying. So proof of income. I think the answer is yes. So not proof of employment income, just proof of how are you going to pay for your rent, basically, show me that you show me like kind of like going back to that 3 times the rent. If there's a policy like that, you have to have 3 times the rent. Then a landlord that has that policy could ask for proof of show me proof that that you're able to cover your 3 times your portion, or proof that the rent is going to be covered, that the income is there to cover the rent. So yes, that the person, right. So that comment there, it just has to be open to other sources of income. That's exactly like the summary of the law. That's correct. So let's see here. So let me see here. Rental obligations to move to rentals. Okay, I'm just reading it. I'll read it out loud. So I'm filling out rental applications to try move in rentals. They ask on applications, what's your employment amount? And I get denied. So that's just going to the same thing I just said before. Okay, I think maybe instead of saying a month's worth of income, I don't know. So I don't know I haven't seen too many, and I don't have too much experience with with all the different ways that it's written on applications, but maybe even a question like, how are you gonna pay your rent? I think a good contact for this, maybe ask the Realtors Association. They were kind of key. They were very heavily, the Illinois Realtors Association was pretty heavily involved in advocating and advocating for passage of this law. So maybe they have some more guidance on that, or otherwise, please, or otherwise contact me off the chat here, contact me privately about that. And so all these things about, can we accept this? I think it all goes, I can't answer like, I don't want to, because it's 2:30 now, so I don't want to answer all these like specific, but I think just the bottom line, the bottom takeaway is that just that there can't be a policy of that all sources of income right need to be considered the same. There can't be a policy that the money comes from a certain place. I know there's more questions. That's why I have my contact info, and I'll share the slideshow. I want to be respectful of everyone's time, and I know that it is 2:30. So I am going to turn it back to Sarah. But you know what? I'll put in the chat again. I won't share my screen again, but I'll put my phone number here's my email address again. I'm just putting in the chat. So if you didn't catch it before, you can, I think it showed up there. Perfect. Yeah, and I'm going to put the phone number as well. That's the phone number as well, just in case you didn't catch that, if you want to contact me. So I am going to pass it back to you, Sarah.
Thank you, Maya. Thank you. Appreciate your presentation. And like she said, we will be sending out the presentation to everyone who registered for the class, as well as the recording. We will let you know how you are able to receive that, just in case there's any technical difficulties. But I am very glad that everybody was able to make it to the presentation, and I hope to see you guys in our next presentation. Will be on the 24th, and it's going to be on affordable housing. So we will be sending out an email with the presentation link and then all of future workshops as well. Thank you, Maya. We appreciate you and all you guys do at PSLS.
Thank you so much, Sarah. And like I said, if you have any questions, please feel free to contact me. And if you're a management company or housing provider and you want to talk more, or maybe have me come and speak with your staff more, that I'm open to that as well. So thank you so much, Sarah. Thank you.
Thank you, everyone.
For hosting this as well.
Thank you. Have a great evening, everyone. Thank you so much for coming.